Hello everyone, and welcome to our business law class. I know in the last few weeks you have probably been getting a little tired of systems and structure and how the law applies in general without getting into some specifics. So today we're actually going to start talking about some specific areas of the law, and hopefully this will be what you've been looking forward to. So today we're going to begin looking at contracts, and this is going to take us a few weeks. And what we're also going to be able to do is look at some of the discussions and cases that we've read over the last few weeks and now view them through a contract law lens. So things should be really picking up right now. Contracts are private law. Very often you think of law as something that the state passes or the federal government passes. But when two individuals enter into a contract, they are creating private law, and the courts will enforce it. It is just as enforceable as any statute that a state government passes. To keep this simple, we will think of contracts in terms of being agreements between two different parties. There can be more parties to a contract, but let's just think of two. And you might think, in general, that a contract is made when there are just two people who have agreed to something. In reality, when we look at whether or not a contract is valid and what the terms are, there are two different people who play two different roles. There is the person who makes the offer, called the offeror, and the person who accepts the offer, the offeree. And so even if you've made a contract before and you're thinking in terms of, well, we came to an agreement, it's much more complex than that. One of you is an offerer, one of you is an offeree. And the key areas we're going to look at in this lesson is the offer and the acceptance, which are two different parts of the contract, and which are both required for that to be a valid contract. And then, assuming we have a valid contract, what the remedies are if someone breaches that contract. Breaching a contract meaning you didn't fulfill your part of the bargain. So let's start with the offer. The offer is think of the offer as being the first person who speaks, whether it's verbally or written or in any other format. I'll come back to this several times. You know what? I'll sell you my car for $20,000. I have made an offer. For an offer to be valid, it's got to have several elements. First, it's got to be intended. If I'm just walking around the office saying, oh, you know, maybe I should sell my car to you, that's not an offer because it's not intended. There has to be a real serious intention on my part to make an offer, not just talking about it. Second, it has to be definite in terms. If I say, well, you know, I could sell you one of my cars, or I could sell a car to you, that's not definite enough. If I say I'm going to sell you my 2015 Chevy Silverado, that's a definite item. Now, every aspect of the contract doesn't have to be made in the offer. That's not how people speak. You don't have to say I'm selling you my 2015 Chevy Silverado for $20,000 and I'll deliver it in January 3rd. Because people don't speak that way, those details will be hammered out through the process. Okay? But it's got to be intended, it's got to be definite, excuse me, and it's got to be intended for an offeree. So if I come into your office and I've heard you're looking for a car, and I say, I will sell you my Chevy Silverado for $20,000, and you say, oh, you know, let me think about that because I'm looking at a couple of different options right now. And the person at the desk next to you says, I'll buy that. That is not a contract. Because my offer is only valid for the intended offeree or offerees. Now, sometimes the intended offerees are a really big class of people. And an example of this is going back to England, 1892. It is a case that is still controlling in England and in the US and in many common law nations. Carlisle versus Carbolic Smokeball. Carbolic Smokeball was a company that invented some fuming incense type of device. And they told everyone through their advertising that if you use one of these 3 times a day, you'll never get the flu. And they were so sure of their product that they printed an advertisement up that said, "We offer to give £100, rather than dollars, this is England, we offer to give £100 to anyone who uses our product and still gets the flu." Well, Mrs. Carlisle used the product, and she got the flu. And she sued for breach of contract because when she asked for payment, they said, "Who are you? We don't have a contract with you. We don't know you from Adam. No contract." The court said, "Oh, yes, you do have a contract. It's called a unilateral contract. When you broadcast an offer to pay $100 to anybody, then the party that you intended to make the offer to was anybody in the public who used your product. Therefore, there was a contract and they did have to pay. But as a general rule, your offer is only valid for the person for whom you're making it." Okay, final comment on that offer. It does not have to be in writing. Contracts, unless they're for real estate, and real estate is a whole different world unto itself, or unless the state has passed a statute saying contracts over a certain dollar amount must be in writing. As a general rule, contracts do not have to be written. It's a good idea, because if there is a breach or a controversy, then you have evidence as to what the contract was all about. But it does not have to be in writing if it's not a real estate contract. So, that is your offer. When you make the offer, you may restrict it in terms of time and space. In other words, well, I'll offer you to sell you my car, but you've got until Friday to respond. Well, if you don't respond by Friday, but on Monday you call up and you say, yes, I want that car, the offer's off the table. It's no longer valid. Now, you can still sell the car if you want to, but you don't have to. And there's no breach of contract because there is no contract to begin with. So you can specify a specific time. You can also revoke your offer if you communicate it to the person. So if you say, "I'm willing to sell you my car, let me know what you think," and you take some time thinking about it, and in the meantime my neighbor says, "Hey, can I buy my car from you?" I can sell it. I have no breach of contract with you because you haven't accepted it, and once I've decided to sell it to my neighbor, as long as I communicate to you the fact that I am revoking the offer is off the table. There is no breach of contract. So I'm making the offer, I can set the terms of it, I decide who it's being made to, I decide what the parameters are, and if you don't accept it within the time frame given or at all, I can revoke that as long as I let you know, and you can't accept it after the fact. We don't have a contract. So that's the offerer. Now we're going to look at the other partner in this process, and that's the person who needs to accept, or the offeree, in order for this to be valid. For an acceptance to be valid, which would make the contract valid, it must be absolute and unqualified. And by unqualified, I mean there's no gray room. You're saying, yes, I accept your offer. There also must be something called consideration for this to be valid. And consideration simply means that the person accepting the offer is giving something in return. It could be a promise to pay. It could be actual payment. It could be a down payment. It could be an agreement that I will do something. If I tell my neighbor, I've got a truck with a plow, I noticed you have trouble with your driveway in the winter, and I promise, just because I'm a good guy, I'll let you know that I will plow your driveway every time it snows. And the neighbor says, oh, that's so wonderful, thank you so much. And then it snows, and I don't plow her driveway. Do we have a contract? No, because she hasn't given anything in return. She needs to be able to say something such as, I agree to pay you $20 every time you plow my driveway. I accept your offer. All we had was a promise on my part, and I blew it and I didn't fulfill my promise. Oh well, that's not a contract. So we have to have this element of consideration. I offer to sell you my car for $20,000, and you say, I promise to pay you $20,000. You've just provided consideration. Each party has to have rights and responsibilities in this. It's not just a nice thing that one person is doing for another. Okay? So, what happens if you generally like the deal that's been offered to you, but you want to change it a little bit? So my wood delivery guy says to me, I can deliver you 2 cords of wood for $400 on Friday. I'm making that offer to you. And I say, ooh, that would be awesome, I need some wood. I accept that price and that amount of wood, but could you deliver it on Saturday instead when I'm home? What I have just done, I have not accepted the offer. Because to accept an offer, you must accept all the terms as presented. What I have just done is I have made something called a counter offer. I am now the person making the offer, and the wood delivery guy is now in the position of accepting that or not. Okay, and this happens a lot. It's one reason why in legal documents between companies, they will very often phrase things in such a way as to not disturb the original offer. In other words, they'll say, are you open to discussing delivery dates? That's just a request for more information. But if I say, no, I can't take the delivery on Friday, but I can take it on Saturday, I have not accepted the contract, or the offer. I have made a counter offer instead, and the original offer is off the table. It no longer exists. It vanishes. So we have no contract. What we now have is an offer being made by me to my wood delivery guy. And the thing is, if he says, well, no, I can't do it on Saturday, and I say, oh, well, okay, fine, I'll take it on Friday, I technically can't do that, because once I made a counter offer, the original offer was off the table and there's nothing to respond to. Now, the wood delivery guy may say, yeah, he may agree to it, and now we've got a contract because I made a counter offer, he made an acceptance, and we're cool. But when you counter offer, the original offer is off the table. As someone accepting an offer, it must be communicated. It must be very specifically communicated. So there's a case where an uncle said to his nephew, "You know what? I'm going to buy your horse from you for $500. I'll be back next week. If I don't hear anything from you, I'll assume the horse is mine and I'll come with the trailer and take him." The nephew did not accept that offer. He didn't say anything. No contract, because it was the uncle who made the offer, and saying, "If I don't hear anything, I'll assume we're good." That doesn't make an acceptance on the other person's part. Okay, there must be an actual acceptance. Silence is not an acceptance. If you accept an offer by post office, and that was a valid way of accepting an offer, the second you put it in the post, it is considered accepted, even if it takes several days or a week to get to the person who made the original offer. It is accepted and the contract is valid. Unless, there's always exceptions to these, courts have held that if you put the wrong address on the envelope on purpose, that's not an acceptance. And that's to stop fraud. If I want to hedge my bets and I'm not sure whether I want to accept the offer or not, so I'll accept it and put the wrong address on it. That way, if I want the contract, I can say, well, I put it in the mail. And if I don't want the contract, the offer never got the mail. And I can have it both ways. And courts have said, no, no, no. You put the right address on, you drop it in the mail, the offer is accepted. Once again, real estate is the exception. You can't accept a real estate offer by mail. When you look at offer and acceptance, the bottom line the courts have looked to is there a meeting of the minds? Does the person making the offer and the person accepting the offer have the exact same concept in mind? Are they talking about the same products, the same price, the same delivery times? Are all the terms the same in both people's minds? If they are, we now have a valid contract. So, this brings us to a 2014 case. And we're going to be seeing more of these in the electronic and online shopping era. So this is a particularly good one because it actually draws in some of the other discussions we've talked about. And that is Wynn versus Barnes & Noble. This is a 2014 case in California. Barnes & Noble made an offer, it was a general offer to the public. We will sell anyone a particular type of tablet for $100 if you order this week. Just go onto our website, order it, and you will get this tablet. Well, Barnes & Noble got inundated by people ordering this tablet through their website. And they didn't have enough. And Mr. Wynn was upset because to get another tablet, he would have to pay a lot more money. So he decided to sue Barnes & Noble for breach of contract. This would be a unilateral contract. And he found out there were a lot of people in the same boat as him, so they filed a class action suit against all the people who didn't receive their tablets. Barnes & Noble said, aha! You can't do a class action suit against us because in our contract it says you have to go to binding arbitration, which is a concept we've discussed. Well, where was their written contract and where was this information? So, a growing area of online electronic purchase and sales law is the difference between something called a click wrap purchase and a browse wrap purchase. And you may have wondered why you have to do some of these things when you buy something online. In a click wrap purchase, you're making your purchase online, and you get to a little box that says, I have read all the terms and conditions of the purchase and agree to be bound by them, and you have to click it. You have to put a check mark in there, or the sale won't go through. That's called a click wrap. That's not what Barnes & Noble used. Barnes & Noble used a system that's called a browse wrap. In a browse wrap, you just go through and you make your purchase, and somewhere on the page they've got a little button that says terms and conditions. You don't have to go to it. You probably don't go to it. They don't tell you to go to it. And once you do click on it, if you do, it's pages and pages and pages of fine print. That's how Barnes & Noble ran their site. Well, the court held that there was no meeting on the minds on these issues because you couldn't be certain that the people accepting the offer to purchase these tablets for $100 had any knowledge whatsoever of the terms of this deal, because the arbitration clause was buried somewhere in a website that you might find if you clicked on it. Mr. Wynn won, and the class action suit was allowed to proceed. The contract was considered valid, but certain clauses in the contract, the arbitration clause, were considered invalid because there was not a meeting of the minds on that particular issue. So, we have a valid contract. An offer's been made, an acceptance has been made, and everyone is on the same page. Most of the time, everyone performs as expected. But what happens if someone doesn't? When someone does not perform as expected in a contract, it is called a breach. When a court has to decide, well, what do we do now that we've had a breach? The go-to remedy is to award monetary damages. And this is called an action in law when there are monetary or money damages awarded to the injured party. In rare cases, we have what's called an action in equity rather than law. And in this case, the court will issue an injunction, which means they are telling a party, you must do something or you must not do something. So let's look at damages first, because that's the most common. One of the most famous cases is a New Hampshire case from 1929. It is Hawkins versus Mcgee, and it is taught to every first-year law student who ever went to law school. It was the opening episode of the Paper Chase, which was a series from many years ago about going through law school, and it's often shorthandedly referred to as the case of the hairy hand. And in this particular New Hampshire case, Mr. Hawkins, as a teenager, burnt his hand on an electric wire and had a disfigured and damaged hand. Dr. Mcgee made an offer to him when he saw it, and he said, I will fix your hand 100% as good as new before your accident if you pay me X amount of dollars and allow me to do the operation. So Hawkins agreed. Dr. Mcgee took a piece of skin off of Hawkins' chest. Skin graft was a brand new concept at this time, and grafted it onto his hand. Well, there were two problems with this. First of all, the doctor screwed up. The skin shrunk, it pulled his hand. His hand's function was worse than before. And because he used skin from the guy's chest, it grew hair. So the guy was now worse off than he was even before. And the court had to make some determinations. They definitely found the doctor in breach of contract. The court had to make some determinations as to how do you value what the damages should be, what the doctor owes Mr. Hawkins. And the decision that came down And it is the decision that is the holding for almost any contract case anywhere in the United States, and that's why this is a famous case, is you value the difference between where I would be if the contract was not breached and the value of where I am because the contract was breached. So in this case, it would be the difference between the value of where I would be, a perfect 100% functioning hand, and where I am, a hand that is even worse off than before. Now, how you assign money numbers to those 2 points is complicated, and that's where you get all sorts of testimony and things like that. But that's the beginning and the end point. Where I should be if the contract was performed, and where I am now. That's your start and end point for determining damages. You cannot get pain and suffering, because Hawkins actually asked for pain and suffering. Cannot get pain and suffering on a breach of contract, and it does not include lost profits unless those profits could be reasonably articulated. Another case for you. 1854, we go to England. It's a contract law case that still controls in the United States. Hadley versus Baxtendale. Hadley was a miller. He ground grain and he sold flour. Crankshaft on his mill broke, so he sent it to Baxtendale to fix it. Baxtendale agreed to fix it within a certain amount of time. Well, Baxtendale was late. So Hadley sued Baxtendale for the lost profits he had because the crankshaft was returned late. And the court held no. You cannot sue for lost profits unless the possibility of lost profits was well known by the other party. All Baxtendale knew was that he had a crankshaft that needed to be repaired. He had no idea it was the only crankshaft. He had no idea that profits would be lost. So you need to specifically say it while you're negotiating your contract if you want to recover lost profits if the other person breaches the contract by not delivering on time. So that brings us to the frozen egg case that I mentioned in the very first video. I deliver eggs in my truck. I bring it to the repair place. They say the truck is repaired. I go to deliver my eggs. The truck breaks down. My eggs freeze and break and I can't sell them. Can I collect damages for lost profits from those frozen eggs? No, I can't. Unless when I originally went to the garage, I said, I have a commercial vehicle that I use to deliver eggs. I need it fixed and it's got to be right by this date or I'm going to be losing profit. If I don't say all that, then if I sue him for breach of contract for not fixing my truck properly, I cannot collect damages for the lost profits related to the sale of eggs. So that was one lost profits case. We looked at another scenario that I had you discuss. You were mediators because we had someone who owned a bookstore and was having a big author signing party, and the night before the author pulls out because he didn't feel well. We talked about the amount she spent on advertising. We talked about the amount she spent on refreshments. We talked about the amount she spent on free giveaways for her store. We never talked about the lost profits that she did not have because the author didn't show up. It may well be that when the bookstore and the author made an agreement for the author to come and sign books that she was selling, that he knew very well that there was going to be a loss in profits for her if he did not show up. And in that case, since the lost profit was reasonably foreseeable and the breaching party knew that that would happen, that he might be responsible for her loss of book profits from the signings and the events and the purchases that never took place that she expected it. So once again, we look generally for money damages, and we look to where would I have been if it wasn't breached, and where am I now? And the difference between those is going to be the monetary damages. General rule, lost profits doesn't count, unless the breaching party had real reason to know that that was a possibility if they breached the contract. Sometimes the remedy of damages, of money damages, simply will not work. And the most common times you will see in the news or hear about contract remedies that are not money damages are where someone has got a no-compete clause with an employee. The employee leaves and goes and starts a new business. Or when there is a non-disclosure form, non-disclosure clause in an employment contract. In that case, the injured party wants to stop someone from doing something. You can't disclose what we talked about. You can't compete against me. And they're going to ask the court to, instead of issuing money damages, issue an injunction, which is a court order saying, thou shalt do this or thou shalt not do that. One of the two. And so the case that I've got for you to look at this week is a specific performance case. It's a non-compete clause, and you'll be able to look at that through the lens of the contract law concepts that we have just discussed. So that's an overview of contracts. We're going to go into more details on some of the quirks of contract law in our next lesson, but that gives you a pretty good overview of what it takes to make a contract, have it seen as valid, and then how to determine the damages if someone doesn't deliver on their part of the bargain. Tom Simmons signing off.